Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Who's for the petitioner, madam?
My lord, I believe the petitioners are from Guwahati, my lord. They have been appearing from Guwahati.
Anyone appearing for the petitioner? Mr. Gaur, we can neither see you nor hear you. Mr. Gaur? Yes. Unmute yourself, please. We can't hear you. Unmute yourself. Unmute yourself. What is the matter about, madam?
Lordship, this concerns the overloading of trucks in the state of Meghalaya and the implementation of weightment devices and implementation of the Motor Vehicles Act in that way.
So you have done nothing.
By the last order, Lordship had directed us to ensure that before the next date of hearing, at least the 23 weighbridges must be in operation. Those have been operationalized. Now,
how many weigh pads have you purchased?
Within a period of 10 days, Lordship, I've made a statement on affidavit before the court that the steps have been initiated for acquiring even those weigh pads.
And how long do these steps take? How many years?
Lordship, in a period of 10 days is what we have said on affidavit.
So your report was filed on 19th. So the 10-day period is over. Have they been installed? The weigh pads?
No, not as on date, Lordship. Supply orders have are to be issued, and Lordship may take it that within the next this week the needful will be done.
Needful will be done, meaning they will be installed.
The supply orders will be issued this week.
All right, and then when will be the next auspicious date for the supplies to be affected?
Lordship, I take it that within a month thereafter it would be affected.
And everything that you're saying is from the top of your hat, without any instructions. Without any instructions.
The instructions are at para 14.
Consult the almanac. Tell us when is the next auspicious day when supply can be made. Then you'll have to find another auspicious day when you can install it. The next date will be when it will be convenient to your VIPs to inaugurate it. Should be about 8 to 9 months. What is the use of your saying in a report filed on 19th that within 10 days it will be done, when after 11 days nothing has been done, even the order has not been placed? The matter pertains to the failure on the part of the state to check overloaded vehicles plying all over Meghalaya. Paragraph. The petitioner is represented on the virtual mode, but due to technical difficulties at the petitioner's end, comma, advocate cannot be heard, full stop. A report was filed, paragraph. A report was filed on behalf of the state on July 19, 2023, which is why the matter was adjourned for some time when it last appeared on July 20, 2023 for the petitioner to go through such reports. Full stop. Though the petitioner's submission on the reports is not available because of the technical difficulties as aforesaid, comma, it is submitted on behalf of the state that such reports indicated that the 23 weighbridges that exist in the state have been made operational and are being used regularly. Full stop. It is the further submission on behalf of the state that pursuant to previous directions of this court, comma, weighbridges are to be installed, and the report indicated that necessary action would be taken within 10 days of the filing of the report. Paragraph. Upon the court querying the state as to the present status of the waypads, comma, it is the state's submission that the supply orders have not been issued yet. Full stop. It is slightly incomprehensible as to why, comma, despite the indication in the report of July 19, 2023, comma, steps have not yet been taken to install the weighbridges. Full stop. How many waypads? Waypads, not weighbridges. How many are you planning to install, Mr. Sahai?
Lordship,
How many waypads are you?
five
Very well.
sets.
The state says that 5 sets of waypads are proposed to be ordered. Full stop. It is hoped that such waypads would be installed and be used within a fortnight from date. Paragraph. The matter will appear 10 days hence, since the petitioner could not be effectively represented today. Full stop. Give it a date after 10 days. Try, Mr. Gaur, once again if we can hear you. Can't hear you. No audio. No audio.
My lord, now,
Yes, now
If
we
I'm
can hear
audible.
you. Yes.
my lord, in fact, my lord, they have submitted the report, but my lord, that report is also not, my lord, as per the lordship's order dated 16/6, my lord. Because in the report, my lord, they only stated, my lord, that they have realized they made the 23 weighbridges operational. They have seen some
After this
measures.
order is made, comma, the audio of learned advocate appearing for the petitioner is restored, and the petitioner submits that even the report filed on
19.
19, 2023 may not be in consonance with the previous directions passed. Full stop. Paragraph. It will be open to the petitioner to ascertain whether and to what extent, whether, comma, and to what extent, comma, the 23 weighbridges which are said to be operational, comma, are functioning, full stop. Hopefully, comma, some of the waypads would also have been installed by the time the matter appears next, and both the petitioner and the state will indicate the places where such waypads have been installed and the other waypads are proposed to be installed. Full stop. Paragraph. The idea is to ensure that the transportation of illegally mined coal in overloaded trucks is arrested, along with boulders being ferried beyond the load-bearing capacities of the national and the state highways. Full stop. The state's focus on or should be on such aspects, particularly now that in certain other areas, the state has been more proactive than in the previous 18 months to stop the illegal business of coal in the state. Yes. Not has been made.
My lord, may I pray that the next date it may be fixed up to 17, my lord. I have some problem up to 17, my lord.
Very well. It will be after 17th.
My lord.
Very well. Fortnight and then give it a date after 17th. Yes.
I yield back.
Item number 2.
May I please, Your Lordship?
Yes.
My Lord, on the last occasion, my Lord, I have submitted that the respondent are trying to have a discussion with the petitioner, my Lord, to settle the matter outside the court.
Problem? What is the problem?
No, last occasion, my Lord, the matter was fixed on June 30th for a discussion, my Lord.
No. What is the problem? What is the grievance of the
What the constitution is, my Lord, that we have no authority to issue patta, land patta, my Lord. So, my Lord, we want to know what is the exact reason, whether there was any such issue which was not addressed of the petitioner.
It's a jurisdictional question. Where is the question of resolution?
No, not
The petitioner says that you don't have any authority.
That is
Whether you have any authority or not, that cannot emerge out of negotiations.
Not
You have to show the law from where you derive the authority.
correct, my Lord. But here, my Lord, we just want to have a sitting with them, my Lord. That is the instruction.
Them standing in court is good enough. No sitting necessary. They are saying you don't have the authority.
My Lord. But some of them, my Lord, they have approached us. They want to have a discussion with us, my Lord. On the last occasion, that could not take place, my Lord, because they had organized
This is a matter where the nature of the grievance is such that it does not admit of any negotiation or resolution.
If my Lord find out,
Only negotiation or resolution is let us share the spoils. You keep quiet, we'll pass on something to you.
well, no, it's not that, my Lord. That's what we are trying to do, my Lord. That is not the instruction that I have, my Lord. So let it come up next week, my Lord. My Lord, can you accommodate one?
No, there is no such instructions with me that there is a negotiation.
Well, we'll just record that they're seeking an adjournment and we'll keep it next week.
My Lord. After 10 days, my Lord, not next week, 10 days.
No, next week. And the issue is such that it does not require any resolution.
That was what I have also informed them, my Lord.
At the request of the respondents, come on, let the matter stand over for a week. It will appear next week.
From the Mingnes, item number 1.
What is the matter, sir?
My Lord, this is with regard to grant of NFFU, my Lord, non-functional financial habilitation and
Non-functional?
financial habilitation and non-functional selection grade to the respondent, my Lord. He is working as commandant in CRPF, my Lord.
Yes.
Now, my Lord, what happened? There were certain disciplinary proceedings against him, my Lord. And because of that, his initial promotion from assistant commandant to deputy commandant was delayed, my Lord. And the disciplinary proceedings culminated in imposition of minor penalty of censure. So because of that, the entire promotion, first promotion as well as second promotion were delayed, my lord. When he approached this honorable court held, my lord, that there was some element of double jeopardy in that.
Absolutely.
Because
Absolutely. All this is done in a sealed cover.
my lord,
What you're doing is you've penalized him by a censure. You're also delaying promotion or grant of financial benefits.
my lord, double jeopardy in the sense that because what happened, my lord, certain motor vehicle were sent for repair, my lord.
Whatever. They're not interested
So
in
there
that.
was a recovery
They're
from-
ended in a censure.
My lord,
What happens is during such period,
my lord,
when disciplinary proceedings are pending, the so-called recalcitrant
My lord.
or delinquent
My lord.
cannot get any benefit.
My lord.
So what is done is his case is considered and the result is kept in a sealed cover. If at the end of the disciplinary proceedings it is found that he is liable to major punishment, then of course promotion and other financial benefits go. But if he gets only a censure or a minor punishment, then the entitlement remains. So if you don't follow the sealed cover process, he has to be given the benefit.
so that was done, my lord, pursuant to the order of this honorable court, my lord.
That was done delayed.
No, that has been restored, my lord. It was done delayed, my lord. After the order of this honorable court, it was restored to his original entitlement, my lord. The original rates of
Very good. Then
promotion as well as second promotion, my lord. Now the second round of dispute, my lord, is with regard to grant of NFFU, my lord, non-functional financial obligation and non-functional selection grade, my lord. These are central government rules, my lord, provide for all this. Now, our case was, my lord, that the certain training requirements are there for promotion to NFSG, my lord, which he completed, my lord, much after. So only after completion of training,
complete it much afterwards
my lord.
because he did not want to do it originally, or did he complete it much afterwards because he was given that opportunity later?
It was given later, my lord.
If he was given that opportunity later, why should he suffer the consequence? Very simple. You tell me that you go get training, from tomorrow you will give you the chaprasi's position. I said, no, I'll do it after some time. I want to be Chief Justice for the next few days. Then I cannot get the benefit. But if you offer it to me late, you can't tell me that because you did it late.
That is one aspect, my lord. The second aspect is, my lord, to be entitled to an NFSG, my lord, he must serve in a certain grade, my lord. Only after that somebody is entitled to. Now here, because of retrospective promotion, all that, effectively he never served during that period, my lord, in that grade, my lord.
Deemed to have served. Again, no fault of
He
his,
deemed to
deemed to have served.
Mr. Mahanta is not,
Who?
Mr. Mahanta is applying for response, but
If he's not required,
he's not required, my lord.
he's not required, why trouble him? Because these are things, if the morale of the in a disciplined force is broken if things like this are done. And sometimes they are done
Well, in
because of personal rivalry, some spite, something or the other. The morale is broken.
well, ultimately everything has been given to him, my lord.
Everything is given
The only question is
charity to him.
some amount of areas, my lord.
You're not doing charity to an employee. That's the employee's entitlement as part of the service rules. For good reason, you can deprive him, but that has to be in accordance with law. You cannot push him to the corner and then say, no, because this is delayed.
It's true, my lord.
Let's finish it off.
Well,
Let us see the
few facts, my lord.
impunity. Yes, tell us the facts.
But at few dates, I'll just. Well, he joined on 24/4/99, my lord.
$24,499
As assistant commandant,
as assistant commandant.
my lord. On 24/5/06, my lord,
Yes.
DPC was held for his promotion to deputy commandant. He was recommended but kept in seal cover, my lord.
Yes.
Because of
When
pendency.
did disciplinary proceedings against him commence?
It comes prior to that, my lord.
Very well. When was the punishment ordered?
3/9, sorry, my lord, 17/5/2008, my lord.
17/5/08,
2008, my lord.
minor punishment of censure.
Minor punishment of censure, my lord. And also recovery of the amount, my lord, from him. Some 2,000 rupees was recovered from him, my lord. 2 or 3,000,
Recovery of
some amount,
2 or 3,000.
my lord.
Very well.
Then, my lord, later on 12/12/2008, DPC was again held and he was granted promotion. 12/12/2008, my lord.
Promotion to
Deputy Commandant, my lord.
Deputy Commandant.
Then later on 21/12/2016, my lord,
Yes.
he was promoted to 2IC, second in command, my lord.
Promoted to
The post of 2IC, second in command, my lord.
second in command.
That's just below the post of commandant, my lord. He approached this honorable court, my lord, in the year 2008 by order dated 14th March 2011.
Yes.
It was directed to consider promotion without taking into account the penalty, my lord. This honorable court directed, my lord, to consider his promotion without taking into account his penalty.
Yes.
But here, the only thing happened by the learned single judge of this honorable court, my lord, did not cause the penalty order, my lord. And that kept some kind of ambiguity in the order.
A minor penalty,
My lord.
generally, unless your service rules say otherwise, is only that, limited to that, no other. Whereas if it is a major penalty, then service rules provide that if it is a major penalty, then consequences follow.
Well,
So over here, minor penalty is censure
Well.
plus whatever is recovery.
well,
But what you're doing is effectively you are also delaying promotion. It's like putting him down in rank, or putting him at a lower scale of pay than what he's entitled to.
Well.
So that is the double jeopardy.
but the learned single judge held because the recovery has also been affected, my lord. So the penalty of censure will amount to double jeopardy.
Will amount to
Double jeopardy. That was the finding of the learned single judge.
anyway. We are not
That
from
was
there.
taken up to SLP, my lord. So
We are not from there.
My lord.
That is not.
then, my lord, pursuant to the order of this honorable court, my lord, review DPC was held on 17/4/2017, my lord.
17/4/2017. What was held?
Review DPC, my lord.
Yes.
And then he was granted notional promotion with retrospective effect, that is, to the post of deputy commandant with effect from 22/7/2006, my lord.
2006.
22/7/2006.
And
And to 2IC.
command.
And to 2IC with effect from 31/12/2012, my lord. 31/12/2012.
Yes.
My lord, he underwent a promotional course
Promotional training.
from 6/11/2013 to 27/11/2013,
Yes.
which is a requirement for grant of NFFU, my lord. So accordingly, he was granted NFFU from
What
1/4/2014.
is that?
FFU, non-functional financial upgradation.
Non-functional
Financial upgradation
financial upgradation.
with effect from 1/4/2014, my lord.
1/4/2014.
And he was granted non-functional selection grade
Yes.
with effect from 22/5/2017, my lord.
22/5/20.
17.
Yes.
Whereas his immediate junior, my lord, one Mr. Keval Kishan, he got an FFU with effect from 1/4/2012, my lord. And NFSG from 1/1/2014, my lord.
And learned judge has asked them to be given from with effect.
From the date the immediate junior was given.
Immediate junior joined on the same day as he?
That
Anyway, they are not
available on record, my lord.
They are not in appeal. It would be right provided we join on the same date. If the immediate junior joined later, he should get it earlier. Anyway, they are not in appeals.
They're not available.
The pension officer? The union is in appeal against a judgment and order of February 10, 2022, by which a single bench of this court has allowed the writ petition carried by the respondent herein and granted certain financial benefits to the respondent, to the writ petitioner, upon holding that the delay in obtaining the requisite criteria for being entitled to such benefits could not be attributed to the writ petitioner. Full stop. Paragraph. The facts are not much in dispute and have been clearly indicated in the impugned judgment and order. Full stop. Paragraph. The writ petitioner joined as an assistant commandant in the Central Reserve Police Force on April 24, 1999. Full stop. However, before the petitioner could be promoted to the post of deputy commandant, for which she became eligible in the year 2006, disciplinary proceedings commenced against him. Full stop. Accordingly, the petitioner's case for the writ petitioner's case for promotion was considered by the Departmental Promotion Committee on May 24, 2006, and the result was kept in a sealed cover. Full stop. Paragraph. On May 17, 2008, the disciplinary proceedings against the writ petitioner culminated in a minor punishment of censure, together with the recovery of a paltry sum of about rupees 3,000 from the petitioner. Full stop. On December 12, 2008, the petitioner was promoted to the post of deputy commandant, and on December 31, 2016, he was promoted to the post of second in command. Full stop. However, paragraph. However, in the year 2008, the writ petitioner instituted the previous round of proceedings, complaining that his promotion had been delayed and that the punishment meted out to him, together with his delayed promotion, amounted to double jeopardy. Full stop. Such writ petition was disposed of by an order of March 14, 2011. Full stop. The part of such order which is relevant for the present purpose is that the employer was directed to consider the writ petitioner's promotion, in the sense that whether the writ petitioner ought to have been granted notional promotion with retrospective effect. Full stop. Paragraph. Accordingly, comma, a review DPC was held on April 17, 2017, whereat the writ petitioner was notionally promoted to the post of Deputy Commandant with effect from July 22, 2006. And the petitioner was notionally promoted to the post of Second in Command with effect from December 31, 2012. Full stop. Thus, comma, by the end of the year 2012, comma, the petitioner became eligible to be considered for the post of Commandant. Full stop. The appellant claims that for the purpose of obtaining financial benefits under the non-functional financial upgradation scheme, comma, an employee had to undergo a training, full stop, according to the appellant, comma, without the mandatory completion, without the successful completion of such training, comma, an employee cannot be considered to be granted the financial benefits under the non-functional financial upgradation scheme. Full stop. The appellant says that since the writ petitioner completed such promotional training between November 6, 2013 and November 27, 2013, comma, he was eligible only thereupon to obtain the NFFU. Full stop. Paragraph. According to the appellant, comma, the petitioner was granted the NFFU with effect from April 1, 2014, and comma, subsequently the writ petitioner was granted, whether as a petitioner to be writ petitioner was granted the non-functional selection grade with effect from May 22, 2017. Full stop. Paragraph. The grievance in the present round, the writ petitioner's grievance in the present round of proceedings under Article 226 of the Constitution was that, notwithstanding the notional promotion with retrospective effect given to the petitioner to the post of Deputy Commandant and, comma, thereafter, comma, to the post of Second in Command, comma, it was not the petitioner's fault that he was required to undergo the training in November 2013, comma, when the petitioner ought to have been afforded such opportunity along with the petitioner's contemporaneous colleagues in the force much earlier. Full stop. Paragraph. It appears from the impugned judgment that the writ court discovered that the immediate junior colleague of the petitioner had been granted, of the writ petitioner, had been granted the NFFU with effect from April 1, 2014 and the NFSG with effect from 1/1/2014. Full stop. The writ court provided that since the petitioner was, since there was no impediment for the petitioner to be granted the financial upgradation and the selection grade, comma, since the disciplinary proceedings against the since the earlier disciplinary proceedings against the petitioner culminated only in a minor punishment, comma, the delay in the petitioner being granted the upgradation and the selection grade was due to no fault on the part of the petitioner. Full stop. Paragraph. It is the contention of the appellant herein that things followed in the usual course. Full stop. The appellant suggests that before the petitioner could obtain a promotion, there was no question of the petitioner being sent for the requisite training. Full stop. The appellant contends that in the usual course of things, the petitioner was afforded the first available opportunity to complete the training, and immediately after and shortly after such training was completed successfully, the petitioner has been afforded the financial upgradation within 4 months thereof. Full stop. Paragraph. The writ court reasoned that since the entire delay in requiring the writ petitioner to undergo the training was on account of the employer and not due to any fault on the part of the writ petitioner, the writ petitioner could not be prejudiced by a junior colleague obtaining the financial upgradation or the selection grade prior to the writ petitioner obtaining the same. Full stop. The writ court, thus, required the appellant herein to extend the financial upgradation under the NFFU scheme to the writ petitioner with effect from the date when the writ petitioner's immediate junior obtained such benefit. Full stop. Similarly, the other direction was that the writ petitioner should be granted the selection grade with effect from the date on which the immediate junior of the writ petitioner obtained the same. Paragraph. There does not appear to be any anomaly in the judgment and order impugned. Full stop. The entire delay in the career progress of the writ petitioner was on account of the disciplinary proceedings which were instituted prior to 2006 and continued till 2000 and culminated in the minor punishment being awarded to the writ petitioner on May 17, 2008. Full stop. As a consequence of this 3-year hiatus, during which the writ petitioner's promotion could not be taken up, the writ petitioner suffered serious prejudice. Full stop. Since the punishment inflicted was a minor punishment and did not amount to reduction in rank or reduction to a lower scale of pay, the effective delay in the promotion granted to the petitioner and the higher pay scales offered to the petitioner would amount to double jeopardy, in the sense that in addition to the censure and recovery that the petitioner suffered, the period during which the disciplinary proceedings remain pending would be counted against the petitioner, was counted against the petitioner for both his promotion and his financial upgradation. Full stop. Paragraph. All that the writ court has done is to correct the wrong that had been been done to the petitioner. Full stop. Since the punishment awarded to the petitioner, no, forget that. Indeed, comma, the writ court reasoned that since there was no reduction in rank or pay that the petitioner suffered, comma, the petitioner could not be worse off than his immediate junior, and that is the basis of the impugned order, and the petitioner being required to be granted the upgradation under the NFFU with effect from April 1, 2012, and the benefit under the selection grade under the NFSG with effect from January 1, 2014. Paragraph, the well-reasoned order of the writ court does not call for any interference, full stop. Justice has been done by restoring to the writ petitioner what the writ petitioner was entitled to, full stop. Paragraph, as a consequence, comma, WA number 11 of 2023 is dismissed. There will, comma, however, comma, be no order as to costs, full stop. Paragraph, it is hoped that the financial benefits that the writ petitioner has been found entitled to are extended to the petitioner, comma, particularly the arrears within a period of 3 months from date.
Item number 2.
May it please your Lordship. Lordship, this is the Shillong Dowkey Road.
Yes.
Since our last report on 10 July, Lordship, there has been some major development. First, there was a Lordship, we've submitted the report.
Any that is the lowest bidder for the private 30% below the bid value. 31% below the joker. Won't be able to do it.
No, Lordship, that is for the
31% below bid value. Either you are completely wrong in your estimate, or 31%. Man, NHIDCL is a regular body. It's not a fly-by-night operator. How can it be 31% below?
That is intriguing, Lordship. I was thinking the headquarters called for explanation, my Lord.
They will come, they will loot and abandon and go.
Lordship, so far state is concerned, we have modified that alignment of flyover, Lordship. That has been approved by the government. And
Yes.
and
Where tender is local? Package 1? Or local tender?
name is not there.
Local contractor? No.
Name is not there.
Anyway, package 2.
Lordship, in the last order of 10th July report, there was a problem in package 2 regarding land, Lordship. That has been resolved by the state, Lordship, only for compensation in the matter.
The two persons,
Lordship is.
Mr. Dhar.
Yes,
Is it Dhar or it should be Dakar?
Dhar, Lordship.
Dhar. And Lamare, they were both agreed.
Lordship, yes.
In package 2, where is the that magnetic institute?
Lordship, if you come through the previous paragraph, they have agreed, Lordship. In according to executive.
NEGRL,
Lordship.
which are also closed, will be shifted 150 meter. Very good.
The cost for relocation will be borne by them.
Naturally, acquisition on relocation will be observed for a year. Meanwhile, continue the work in the site with atmosphere till the clearance now.
So this was a major hurdle, Your Lordship, at least.
Very good. Yes, that's a major hurdle because there is no place on the other side.
So except for the package 5, Lordship, some package 4, we have some.
Package 3 Peninsula
Lordship.
have to be package 4 take up matter reading remaining 25 monsoon bypass change of alignment.
So, Your Lordship, we are trying to invoke the urgency clause and take position and then allow them to settle the dispute. This is litigation only, Lordship.
But then you'll bleed. You're for the state.
Lordship, yes.
You'll bleed if you take that's and for how much? 0.182 kilometers.
Lordship.
That is nothing. For that you can afford.
So we are working on possibilities of taking position, invoking the emergency clause
Because
and
if it was anything much more,
Lordship.
0.182 kilometers may not be.
So Lordship, we are in advanced stage of working and trying to work out permutation combination, Lordship. So far state is concerned, Lordship, so far land is concerned, we are right earnest.
Package 5, advanced possession, Maoryang. Umsem is Dauki.
Lordship.
Umsem village is where Dauki is.
Lordship. Again, it's pending settlement of the ownership, Lordship. It's all private
Very
land.
well. A short status report pertaining to the Shillong-Dauki Road under the JICA funding has been filed in court to the Joint Secretary, Public Works, bracket R&B, bracket close Department of the State. Paragraph, it is encouraging that several of the impediments appear to have been removed and work in respect of all 5 packages may be ready to be awarded. Full stop. Paragraph, it is recorded that the modified alignment of the flyover at Jhalupara has been approved by the state. Full stop. Even more significantly, comma, what is that NEGRL?
Lordship, I was just trying to find out, but what we see is
It's
Indian Institute of Geomagnetism, Lordship.
more what?
Indian Institute of Geomagnetism.
Comma, the Indian Institute of Geomagnetism comma, which had earlier stood firm in its refusal to part with any land, comma, has graciously consented to shift by approximately 150 meter, comma, subject to the relocation cost being borne by the National Highway Infrastructure Development Corporation Limited. The institute has agreed that work on the relevant stretch can continue even though the ultimate fate will depend on the readings of the relocated positions of the relocated position of the observatory.
Lordship.
Full stop. There is no doubt that even such aspect can, comma, ultimately, comma, be resolved. Paragraph. As to the second package, it appears that 2 of the landowners have withdrawn their objection. Full stop. However, a third landowner has not collected the compensation award. Full stop. It is hoped that the Deputy Commissioner of East Khasi Hills ensures that such third person does not stand in the way of the work on the second phase being undertaken. Full stop. As to the third package, the modified alignment of the Peninsula bypass has been finalized by the state. The new alignment will be forwarded immediately to NHIDCL and the relevant ministry for final approval. Full stop. The detailed survey for acquisition of land, forest clearance and shifting of utility lines may be taken up only after the approval. Full stop. This part of the project appears to be delayed, but there is agreement on the part of the state, and it is hoped that if the new alignment meets the approval of the NHIDCL and the ministry, the urgency provisions in the land compensation statute will be invoked to acquire the land. Paragraph. In respect of the fourth package, both the state and the NHIDCL are on the same page that the alignment cannot be altered. Full stop. The state has now to negotiate or otherwise acquire some land. Full stop. The report indicates that the contract awarded has to be foreclosed since no activity could be undertaken. Full stop. It is hoped that matters pertaining to such fourth package are expedited. Full stop. In respect of the fifth package, the Deputy Commissioner of the East Khasi Hills District has been directed to take advance possession of the land through which the proposed road will pass in Wakdet, Mauriang and Umsiem villages. Full stop. Apart from such portion of the work, the tender for the balance work has been invited and the bids are expected to, and the last date for bids has been fixed on August 2, 2023. Paragraph. As far as the present matter is concerned, which pertain to the felling of trees for the proposed Jhalupara flyover, the subsisting directions will continue, semicolon, that is to say, that only upon actual work commencing will the remainder of the trees be felled, and the felling of the trees should not be completed any earlier. Full stop. Paragraph. It is hoped that the work in all 5 packages commence and continue in right earnest, as it is essential to have a widened corridor to Dauki, as well as a flyover to ease the congestion at the entry point into Shillong in the cantonment area. Full stop. The matter will next appear 6 weeks since.
Item number 3.
Your